Hello, everyone. In this lecture podcast, I will talk about constitutional rights and freedoms. Before we start talking more deeply into the topic, let's begin by talking about the nature of constitutional rights and freedoms in Australia, especially as it is opposed to how it might be, for example, in the United States. So in Australia, although we have a written constitution, just as the United States of America does, we don't have a written Bill of Rights in the Constitution. In the United States, there is one. So in other words, as far as trying to determine what the fundamental rights and freedoms are of people or the citizens in the United States, you easily have recourse to a set of rules or a set of or a written document that outlines and details the fundamental rights and freedoms of people that are constitutionally protected. And this means, therefore, that there can be no law that the United States Congress or any state in the United States can pass that would contravene the Bill of Rights, because otherwise any such law would be deemed unconstitutional. In the case of Australia, however, we don't have a written Bill of Rights. And as a result, we are left with a situation where we look for certain expressly stated constitutional rights and then attempt to determine what the implied rights might be as determined by the High Court. And so given that backgrounder, we will then try to examine some questions or some case problems that any citizen might be confronted with. And for example, let's begin by asking the question, would it be permissible, for example, for a law to be passed whereby the Commonwealth Parliament or even a state legislature may say that any Australian citizen or subject can be arrested even without any cause for any justifiable reason? And would it also be permissible, let's say, to detain an Australian citizen or subject in Australia without any judicial warrant, let's say for a period of a month or even for 6 months? Would it be permissible also, for example, for such persons in detention not to be given a right to a lawyer during the time that they are detained? So that'll be one question that we'd like to think of, because imagine a situation where you're suddenly arrested by the police and detained and you don't really know, what your rights might be. And so that's one area, and it might be possible as a lawyer later on, you'll be confronted with a situation where you have a client who has been detained by the police and yet no charges have been filed in court. And yet you'd like to determine whether or not the police in that instance might have gone beyond whatever powers that they have been reposed in by a Commonwealth Parliament law or a state legislation. Secondly, as we all know, there is this constant talk about spying and surveillance, and this brings the notion of Big Brother in the sense that there have been attempts, even in the United States, to try to spy on its own citizens. In the United States, for example, there have been accusations whereby they've attempted to even spy on the heads of states of other nations, whether it's Russia or Germany or Indonesia or even Australia. And what if we are put in a situation where a Commonwealth Parliamentary Act is passed, giving the powers, for example, to the federal police or the ACO, the power to spy on any citizen, the power to intercept emails, the power to listen in on all mobile phone communications? Do you think that would be legal and constitutional? Or how about a situation where, out of anger, an Australian or even a non-Australian in Australia would burn the Australian flag? And that seems to be an affront to sensitivities of Australians. Would that be permissible? And what if there is a law that criminalizes that kind of action? And how about this idea of an ex post facto legislation whereby somebody does an act, let's say in 1980, And at the time that act was done, it was actually lawful. And then sometime in the year 2015, meaning this year, that's about 35 years after, the Australian Commonwealth Parliament would then pass a law saying that something that you did in 1980, which was then legal, is now a criminal act, and hence you are then liable to criminal prosecution even for that act in 1980, even if at the time it was committed, it was perfectly legal to do so. And you can easily talk about instances of abortion or euthanasia, which may be legal at some point, and then it is determined by the Commonwealth Parliament that that act was criminal in the first place. So it's considered an ex post facto legislation. Would that be valid and constitutional? Or how about a situation where the Commonwealth Parliament passes a law that says that anyone who is identified as being part of an Islamic movement, Islamic terrorist movement, and who provides support in the form of money or even arms or whatever support, is deemed to have committed the crime of terrorism, and as a result, they are guilty of terrorism and then subject to imprisonment, say for 2 years or 5 years or whatever, without that matter having to go to the court. Would that be permissible? And what if during certain elections, or even during periods where there is no election, and you have a blogger that denigrates and attacks the Prime Minister of Australia or the Queensland Premier or the heads of the other states in Australia, or attacks the personal character of an executive officer on the basis of violations of some code of conduct or ethics? Would that kind of activity or behavior be constitutionally protected, or would that be subject to criminal liability without any defense as founded on the Australian Constitution? So these are some of the key issues that we will confront as we go through this lecture podcast. So after studying this topic, you should be able to discuss and explain the constitutional basis for the rights and freedoms of Australians, despite the absence of a Bill of Rights. You should also be able to discuss and explain the constitutional constraints on governmental powers to interfere with the rights and freedoms of Australians. You should then also be able to discuss and explain the implied freedom of political communication and freedom from arbitrary detention, and discuss and explain how and why an ex post facto law can be valid in Australia. So let's proceed. Now, if you look at the Bill of Rights of the American Constitution, for example, in their Constitution, you would come across these important rights, or what are known as fundamental rights and freedoms. One of them would be freedom of religion, freedom of speech, freedom of assembly and association, freedom of the press, right against unreasonable search and seizure, right to speedy trial, right against self-incrimination, right to due process, right against ex post facto legislation, rights against bills of attainder, rights against double jeopardy, and rights against excessive bail and cruel and unusual punishment. Now, obviously, apart perhaps from the freedom of religion, which is guaranteed in the Australian Constitution, all of these rights and freedoms, which are part of the Bill of Rights in the United States, and actually also of the Philippines and other countries which have patterned their written constitution to that of the United States, these are the common fundamental rights and freedoms that would be found in their written constitutions. But these don't exist in the Australian written constitution, except for the freedom of religion. Would it mean, therefore, that these rights and freedoms do not exist in Australia, or that these rights and freedoms are not constitutionally protected in Australia. So let's think about that for the moment. Again, in relation to the examples I gave earlier of potential problem areas of any citizen or subject of Australia, and you might come across a client, especially if you're practicing in the area of criminal law later on as a solicitor, and you're confronted with these instances when some rights and freedoms which assumed you existed have actually been violated by actions of the police or officers of the executive government. Now, let's begin by talking about the express constitutional rights. There are at least 4 express constitutional rights found in the Australian Constitution. One of them is in relation to the right to compensation on just terms for property acquired by the Commonwealth, and that is provided in Section 51, subsection 31, where the Constitution provides that the Parliament has the power with respect to the acquisition of property on just terms from any state or person for any purpose in respect of which the Parliament has power to make laws. And again, although that's an express written constitution, again, what you need to remember is that this is a provision or a grant of power to the Commonwealth Parliament. It clearly provides that if the Commonwealth Parliament were to pass a law where it's sought to acquire property from any state or any person, then such acquisition must be on just terms. However, it doesn't state that states are limited by that same provision, which raises the question of whether or not states can justly or can validly acquire property from any person within the state without providing compensation on just terms. And the answer, in all likelihood, will be that it could. In other words, a state is not limited by the same constraint that is found in Section 51, subsection 31. So in other words, it's permissible, it would likely be permissible for any state to acquire property of any person within the state without having to pay compensation on just terms. Secondly, the right to trial by jury, which is provided in Section 80 of the Australian Constitution. And again, it raises the question, would that right to jury be applicable to whether or not the violation or the offense was based on a Commonwealth criminal legislation or a state legislation? And again, based on Section 80, the right to trial by jury relates to any offense against any law of the Commonwealth. It does not include any offense based on state law. So in other words, if a person commits a crime based on a state legislation, then Section 80 doesn't apply. And it would then be permissible for the state to legislate that that person can have a criminal trial without a jury, because Section 80 only applies to Commonwealth legislation. Thirdly, as we studied before, there is a constitutional right under Section 92 to interstate trade and commerce. And in particular, Section 92 provides that on the imposition of uniform duties of customs, trade, commerce, and intercourse among the states, whereby by means of internal carriage or ocean navigation shall be absolutely free. And obviously, that constitutional requirement prevails mainly because the Commonwealth Parliament has already imposed uniform duties of customs, trade, commerce, and intercourse among the states. So there is a right of interstate trade and commerce that we previously discussed, and it's important, therefore, for us to realize that the right to trade and commerce across states cannot be bound or constrained by Commonwealth or state legislation, except for those instances which we discussed previously, such as when there is a need to regulate an activity, and that will not be a relevantly discriminatory law and would be permissible if the purpose is regulation, and only to the extent that such regulatory activity is necessary for the purpose of achieving the aims of the regulation. And finally, there is a freedom of religion, which is also found in the Constitution. And in particular, Section 116 provides that the Commonwealth shall not make any law for establishing any religion or for imposing any religious observance or for prohibiting the free exercise of any religion, and no religious test shall be required as a qualification for any office or public trust under the Commonwealth. Which again brings us to that point that Section 116 is a constraint on the Commonwealth Parliament. It is not a constraint on state parliaments. So this would indicate that it will be permissible for the states to establish religion or to impose religious observance, or to even diminish the free exercise of any religion. Although that again will certainly lead to the question of whether or not, if there is an appropriate test that is given, if the High Court will in fact sanction any such state law at this present time, when the freedom of religion is already something that is a commonly observed right across most democratic nations. So the constraint only is that a religious test is something that cannot be permitted both in the Commonwealth and in the states, because Section 116 provides that no religious test shall be required as a qualification for any office or public trust under the Commonwealth. So in other words, it applies both to the Commonwealth and the states. Now, moving on, if there is no Bill of Rights, and we would like to argue that there are certain fundamental rights and freedoms that are constitutionally guaranteed, but they don't find expression expressly in the Constitution, can we say that there might be certain implied constitutional rights? And the answer is yes. There are at least three bases for an implied for making the case of implied constitutional rights as recognized by the High Court. And one is that in the case, for example, of Australian Capital Television Proprietary Limited versus the Commonwealth, the Australian government is based on a federal and representative nature, which means, therefore, that if Australia has a federal nature, then there are certain rights and freedoms that must be observed in the Commonwealth and in the states that would serve to enhance the nature of the Australian government as both a federal government and as a government that is representative. And we're going to be examining this implication in greater detail in a short while. In the case of Australian Capital Television Proprietary Limited versus the Commonwealth, it was Justice Godron who also said that Australia is a free society governed in accordance with the principles of representative parliamentary democracy. And on the basis of that assumption, it will then mean that there are certain constitutional rights and freedoms that must be guaranteed if the principle of representative parliamentary democracy is to be observed and pursued. And finally, the third implied constitutional right and freedom would be based on the assumption of the partial separation of powers, which, based on the Boilermaker's case, makes an assumption that there are certain matters which are left solely for the judiciary to determine. And any law, therefore, that might be in breach of the powers of the judiciary would be deemed unconstitutional. And the implication, this has an implication, for example, on a law that is actually a bill of attainder, which means that there might be a law which says that anyone who belongs to an Islamic party or someone who belongs to an Islamic terrorist group, whether or not that person is actually involved in armed conflict, will be liable to punishment to, let's say, 5 years without need for any trial or determination by a judge. So that would be a bill of attainder. And the question would then be, would that be permissible? So these are some of the questions that, again, we will go back to on the basis of the sources of implied constitutional rights and freedoms. So if we speak about implied constitutional rights, there are at least 6 that we should certainly look at. The first is the freedom of political communication, which was recognized by the High Court in the case of Australian Capital Television Proprietary Limited versus the Commonwealth, where the High Court ruled that Australia, being a representative parliamentary democracy, it is implied that freedom of political communication has to be guaranteed. And what this means is that communication that is of a political nature, even if it may be offensive to the sensitivities, or even if it may be an affront to the character of, let's say, heads of the Australian executive government, or to government ministers or state ministers, any such communication, as long as it is intended to be a way of ensuring public accountability by public officials, would be protected by the implied freedom of political communication. And as a corollary to that, this would also mean that the freedom of the press, which again is a separate constitutional right in the United States Constitution, in its Bill of Rights, would likely and would be part of the freedom of political communication. So the freedom of political communication applies or is available to the citizens of Australia as well, obviously, as the press that are in Australia. Secondly, there is another implied constitutional right, and this is the freedom from arbitrary detention. So in other words, detention by itself, the power, let's say, of the federal police or to detain a person is not necessarily unlawful or illegal. What is not permissible is arbitrary detention. And when you say that it is arbitrary, you would usually argue that it would be arbitrary if there is no legal basis for the detention. And in the case of Chu Ken Lim versus Minister for Immigration, Local Government and Ethnic Affairs, the High Court ruled that it has always been the practice of the courts, especially in the UK, and obviously prior to the Federation of Australia, that there is a freedom from arbitrary detention, and the courts have the power to examine the authority by which the king or any of his servants may detain a subject of the kingdom. And that same freedom applies in Australia. So there is a freedom from arbitrary detention. And again, that leads us to the question of assuming that there is a legal basis for a detention. So the legal basis may be because there is a statute that authorizes it, or certain exigencies may require immediate detention in the sense that, and of course this is in statute, but assuming it was not in the statute, the power, for example, of the police to detain someone who might be attempting to commit a crime, such as use a gun to kill people, that would be a right that would typically, that would be an instance when there could be detention, but that detention would not be considered arbitrary, that would be legal. However, would it be permissible, for example, for a law to be passed by the Commonwealth Parliament which states that a person can be detained, let's say, for a period of 30 days or even 60 days, even without any charges having been filed before a court, and without a court, therefore granting a judicial warrant that would violate the continuing detention of a person? So there is that implied freedom from arbitrary detention. And so I would argue that a detention, for example, let's say of 10, maybe 12 days might be arguably detention that would be permissible if the purpose of that would be to ensure that no crime is committed, or to ensure that the presence of that person will be guaranteed for the purpose of him presenting before the court. That would be allowed following Chu Keng Lim versus Minister for Immigration, Local Government and Ethnic Affairs. But for an Australian citizen to be detained by the police without any judicial warrant beyond, let's say, 15 days, arguably would already be arbitrary detention. And a case can be made for an application for the issuance of a writ of habeas corpus, which is an equitable remedy recognized by the courts, whereby that person or a legal representative can come before the courts to ask the police officer detaining a person, or the executive officer detaining a person, to explain to the court whether or not the detention is legal or not. So there is an implied freedom, therefore, from arbitrary detention. There is also a right to vote, which is impliedly assumed in the Australian Constitution on the basis of a representative parliamentary democracy. And mainly because if we examine the election of the members of the Senate or the members of the House of Representatives, it says that those representatives will be elected by the people. So therefore, it said there is a right to vote, which is an implied constitutional right based on the Constitution, as well as the fact that we are a representative parliamentary democracy. And if we are to be a representative parliamentary democracy, then the right to vote has to be guaranteed. However, the right to vote does not equate to a universal right to vote. In other words, it is still up to the Commonwealth Parliament to determine qualifications or disqualifications of voters or electors. So the High Court in McGuinty versus Western Australia was unprepared to recognize a universal right to vote. So the right to vote is subject to constraints or limitations that the Commonwealth Parliament may impose. And in one of the cases that we looked at before, the High Court validated the power of the Commonwealth Parliament to impose as a disqualification against voting in those instances where a person is in prison for committing a crime, and that person has then been subjected to imprisonment for a term of 5 years or more. The High Court, however, ruled that in that instance where the term of imprisonment was only 1 year, that violated the right of that person to vote. In addition, there is an Australian notion of due process. And what exactly does due process mean? If you look at the United States constitutional practice concerning due process, because due process, again, the right to due process is an express right guaranteed under the United States Constitution, it means that any person who comes before the court has the right to due process. It means that he has a right to fair trial, he has a right to an attorney, he has a right to ensure that evidence that is used against him in a criminal prosecution was validly taken. And so this is an example of due process. Or the right to confront witnesses in a criminal prosecution. This would be part of the notion of due process in the United States. And so let's say there is a situation where the police, entrap a person to commit a crime. So in other words, let's assume that there are undercover police officers, and so we're speaking of a situation where you have an undercover police officer who then attempts to, or who disguises himself as a drug dealer, and he then sells drugs to a person for the purpose of getting that person to commit a crime. The question is, would that be legal? In the United States, that would be illegal because that violates the right of the person against to due process. Or you might have a situation where somebody just barges into the house on the basis of a rumor. I mean, the police would barge into the house on the basis of a rumor, and in doing so, they then come across drug paraphernalia or evidence of a crime or prohibited goods or contraband material, and then they would then prosecute that person. In the United States, there is a right against unlawful search and seizure, and that would typically be part of the due process clause as well. And as a result, in the United States, for example, if evidence was seized as part of something that was initially unlawful, so in other words, if there was an unlawful arrest, then any evidence that may have been found as a result of that unlawful arrest will be tainted. And because it is tainted, that cannot be introduced as evidence in the United States as part of a criminal proceeding, because it is a fruit of the poisonous tree. Now, we should state clearly that the kind of due process that is observed in the United States does not apply in Australia. Although, arguably, there is an Australian kind of due process as a result, for example, of Fenkut versus Muller, or the Boilermakers case. And the assumption mainly is that because judicial power lies with the judiciary, for example, then part of the due process requirement is that the ascertainment of guilt must be made by the courts. The determination of an actual controversy can only be done by the courts, and not, for example, by the executive. So that, again, is an implied assumption that we can make that there is an Australian notion of due process. And the right, for example, to a hearing, although it is not founded constitutionally, meaning it is not expressly guaranteed in the Australian Constitution, it can be argued on the basis of an Australian notion of a due process clause that it is a guaranteed right, an impliedly guaranteed right, the right to due process, or the right to a hearing, or the right to a fair trial by a judge who is impartial and who is objective and free from bias. So that would be based on Fenkut versus Muller. We can argue in Fenkut versus Muller, for example, the court emphasized that the exercise of due power involves the, and I quote, the quelling of controversies by the ascertainment of facts, by application of the law, and by exercise where appropriate of judicial discretion. So this again tells us, going back to the issue of the notion of matter involving actual controversies, there are certain proceedings which are solely left to the courts. And because of that, therefore there are certain guarantees which can be derived from those notions of what constitutes judicial power, and what can be derived would be an idea of the due process clause, so-called due process clause in the Australian Constitution, such as the right of guilt to be determined by the courts, the right to a fair trial, and the right to hearing, and so on. Now, in relation, for example, to the notion of the fruit of the poisonous tree, going back to the Boilermakers case, what this also tells us is that if you remember the Boilermakers case, the High Court ruled that it was not permissible under the partial separation of powers that is observed in Australia. It was not permissible for judicial power to be vested in non-Chapter 3 courts. That was one. The second principle that they enunciated was that it was also impermissible for non-judicial power to be vested in Chapter 3 courts. And as a result of the Boilermakers case and the legal propositions that emanated out of that specific decision, again, there is a due process clause that can be implied from those principles. And this essentially means that if it involves, for example, the exercise of judicial power because it involves a matter or an actual controversy, it would be impermissible for an executive officer to make a determination involving matter. And so this would mean, therefore, that it would, for example, be impermissible for the Commonwealth Parliament to pass a law that provides that a non-Chapter 3 court will determine the guilt or innocence of a person who has committed a crime. Because in that case, that would violate the Boilermakers case. And that would be considered part of the due process clause. So part of the due process clause would be to say that if it is the guilt or innocence of a person that is involved, only a Chapter 3 court or a Chapter 3 judge, as part of a Chapter 3 court, would be permitted to examine the guilt or innocence of a person. Now, let's talk about the fruit of the poisonous tree. Again, I said before that in the United States, if evidence was obtained as a result, for example, of an unlawful arrest, or as a result of an unlawful seizure. So an unlawful arrest would be like, the police, sees a person, and because he looks like he's Chinese or he looks like he's a jihadi, by the way he acts, or the way he wears clothes, then based on that kind of racial profiling, then they would come to the person and then start checking, asking him to clean his, show his pockets, show his wallet, and in doing so, and they may even frisk the person, and in doing so, they come across illegal goods or illegal material, whether it could be a gun, an unlicensed gun, or it could be illegal drugs. Or in the United States, it may be that somebody was just driving in the middle of the night, doing something perfectly honest and something perfectly legal, and the police in the United States just stops the person and then asks the person to open his trunk because they just want to check if all is good. In the United States, in those two instances, that time when a person was stopped, that would already be considered as part of an arrest, not in the arrest in the formal sense of somebody being placed in handcuffs, but the fact that that person was stopped by the police, that's the time when arrest is meant to take place, because there has been the restriction of the freedom. And if in that process, because there was no valid ground for the arrest of that person or the detention of that person, even for a fleeting moment, when he was then asked to open his pockets or open his wallet, or when he was frisked, illegal material was then discovered, that illegal material is not admissible to prove that that person committed a crime of possession of illegal drugs or an illegal gun or an unlicensed firearm, because those items would have been fruits of the poisonous tree. They would be outlawed. They cannot be used in evidence. Or, for example, somebody was invited to the police station in the United States and say, "Oh, we've heard that you were part of this crime, that you committed this crime. Why don't you tell us about it?" And then, in the absence, without that person having been given the Miranda warning, which includes for the police to actually state to the U.S. citizen, that he has a right to a lawyer, that he has a right against self-incrimination, that he has a right to remain silent. No. So if that person were not Mirandized in the United States, and in the course of an invitation to the police, he then made a confession, because the process of that person having been detained or being questioned violated the Miranda warnings, meaning he was not Mirandized, then the evidence he would have given, meaning the confession that he would have made, would be deemed to be inadmissible in court, even if that would have been the only evidence that would show his guilt. And the reason for that is that is the fruit of the poisonous tree. In Australia, however, we don't have a guarantee against unlawful arrest and seizure. And so therefore, the notion of the fruit of the poisonous tree does not apply, which tells us that even, for example, even if a person were unlawfully arrested and detained, and as a result of that unlawful arrest or detention, evidence was then obtained or gathered, it raises the question of, would that evidence be admissible in court? Think about it. So there was an unlawful arrest, and then there was evidence of a crime that was then obtained as a result of that unlawful arrest or detention in the United States. That obviously, that illegal evidence, that contraband or the evidence of a crime would be considered fruit of the poisonous tree and would easily be thrown out of the court. What if it happened in Australia? Would the fruit of the poisonous tree apply? And the answer is no, it won't. So you can have a situation where there was an unlawful arrest, but in the process of that unlawful arrest, the police then discovered unlawful paraphernalia or illegal drugs. You have a problem. You're in trouble. And the perfect example of that is the case of Fencott versus Mueller, where what actually happened was that there were some undercover law enforcement officers who imported drugs into Australia for the purpose of selling it to an accused. And when the police did this, when they imported the illegal drugs, meaning from abroad, they actually did not have any legal authority to do so. So they themselves had violated the Customs Act. And so the accused then sought to have the evidence excluded because of the unlawful actions of the law enforcement officers. Because they themselves had been using, as evidence, drugs that they themselves had illegally obtained, for which they themselves were accountable under the Customs Act. And what the Parliament then did was to amend the Crimes Act of 1914, where they then stated in the Crimes Act of 1914 that, notwithstanding the fact that evidence was gathered or obtained by police officers or law enforcement officers on the basis of an unlawful conduct or behavior, it was up to the judge to disregard the unlawfulness of the behavior or the actions of the law enforcement officers. And the question was, would that amendment, for example, then be valid? Because in that case, it actually said that notwithstanding unlawful behavior of the police, the evidence that was obtained as a result of that unlawful behavior can still be used by the court or can still be used as evidence in court, subject to the discretion of the judge. And the High Court ruled that that particular amendment was not in violation of the Constitution because it merely served as a rule of evidence, and so therefore it did not violate any implied limitation concerning due process. So in that case, the High Court ruled that it was valid, it was legal. So at the time it was committed, there was a clear question about the legality of using unlawful evidence. But on the basis of an amendment under the Crimes Act of 1914, the High Court ruled that the amendment was valid, and so therefore it was permissible to use evidence that would otherwise have been admissible in the United States. It was permissible for it to be used in a criminal proceeding in Australia, subject to the discretion of the court to accept that evidence. So in Australia, it can be permissible for evidence that would have been unlawfully obtained or seized to be used in a criminal proceeding, subject to the discretion of the trial judge, whether or not it would be willing to disregard the unlawfulness of the behavior. Okay, now, so having explained that, let's talk about the Equal Protection Clause. In the United States, again, there is a guarantee of an Equal Protection Clause. What this tells you that people who are of the same circumstances should be treated in the same way. So in other words, it would be impermissible for a law to be passed whereby it discriminates on the basis, for example, of race, or on the basis of sex, or let's say on the basis of intelligence, or on the basis of wealth. They would be discriminatory because it would violate the Equal Protection Clause of the Constitution. It guarantees people who are similarly situated to be treated similarly by the law. That is under the Equal Protection of the Laws Clause. So therefore, for a law to be passed which would discriminate, for example, against Hispanics in the United States, or against Chinese, or against immigrants who have now settled in the United States, that would be a violation of the Equal Protection Clause as guaranteed in the United States Constitution. We don't really have that in Australia. In Australia, however, we might have something that is a bit close to the Equal Protection Clause in the Constitution, because under Section 117, it says that under Section 117 of the Australian Constitution, it provides that a subject of the Queen, resident in any state, shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were a subject of the Queen, resident in such other state. And you begin to wonder, why is that kind of provision kind of vague, quite broad? Why didn't they just say that Australian citizens or subjects have a right to equal protection? And why did it use the word subject and say resident in any state? Because the protection is a subject of the Queen, resident in any state, shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were the subject of the Queen, resident in such other state. So the question arises, for example, in Australia, would it be permissible to discriminate, let's say, against the Chinese or against Asians? Or say that no person can be hired if their English is not good enough. And so therefore they need to have an IELTS score of, let's say, 6.5. I'm not really sure if you know what IELTS means, because the assumption being that you don't have to take the test. Would there be a requirement, for example, that somebody must speak very good English before they can be hired by a private employer in Australia? Would that violate the Equal Protection Clause? And the answer is likely not. In a sense, they would be valid and legal, because there is no Equal Protection Clause in Australia. So discrimination in Australia against Hispanics on the basis of race, for example, or on the basis of religion would not be allowed in the United States, but it would be permissible in Australia. It hasn't been tested yet, but if you look at the Australian context, it will be possible to argue that it would be legal for discrimination, in a sense, to be made on the basis, let's say, of race or gender, because the Equal Protection Clause does not exist. And this is the reason why, if we go back to the history of Australia, the right to vote, for example, was not granted to the Indigenous people of Australia initially. Neither was the right of women to vote initially available in Australia. And it was also excluded, the right to vote was also excluded to certain races, including the Chinese. So in that case, there was no violation of the Equal Protection Clause because it does not exist in Australia, save for that of Section 117. So the kind of Equal Protection Clause that is available in the United States does not exist in Australia. However, on the basis of Section 117, there is a limited Equal Protection Clause that is available. And finally, the other constitutionally implied right that we can speak of is the right against the Bill of Attainder. So, and we will be talking about the case of Polyukovich in a short while. So let me just check if, yeah, okay. So the right against the Bill of Attainder provides that no law can be passed by the Commonwealth Parliament which adjudges the guilt of a person on the basis of a legislative or executive determination. So if there is a law passed by the Commonwealth Parliament whereby it defines or it leaves it to the executive to define or identify a person or a set of persons as having committed a crime, and then on that basis adjudge them guilty and then meet or provide a punishment, that would constitute a Bill of Attainder. And that would, in the case of Polyukovich versus Commonwealth, offend the Constitution not because there is in Australia an express notion against the Bill of Attainder, but because it would violate the partial separation of powers guaranteed by the Constitution. And one of the assumptions of the partial separation of powers is that the power to determine the guilt or innocence of a person is exclusively an exercise of judicial power and cannot be exercised by the legislature or by the executive. So that is a right against the against a Bill of Attainder. So a Bill of Attainder is a law whereby a person or a set of persons are determined or identified to be guilty of a crime and subject to punishment, even without a determination made by a Chapter 3 court. So that would be a Bill of Attainder. And that is deemed to be, so any Bill of Attainder in that sense would be invalid and unconstitutional. However, although a Bill of Attainder actually is, in a sense, an ex post facto law. And what exactly is an ex post facto law? It is a law that criminalizes an act or behavior that at the time it was committed was actually legal. So you might have committed an act today, and it is legal to do so, and then maybe 5 years from now or even a year from now, a law is then passed that what you did the year before is a crime, and therefore, the question is, would it be permissible for the police to file a criminal complaint against you in court? So that would be an example of an ex post facto law, because it is a law that criminalizes past behavior. On the basis of a past behavior, a behavior which at the time it was committed was actually legal or valid to do. And the High Court in Polyukovich versus Commonwealth made it clear, the court ruled that ex post facto legislation is permissible. in Australia, because at the time of federation, although the framers of the Australian Constitution were aware of the existence in the United States Constitution of the prohibition against ex post facto legislation, they decided not to adopt it in Australia. And so therefore, it would be difficult to interpret that in Australia, the ex post facto legislation would be prohibited. So the High Court was unwilling to allow that. So therefore, in Australia, ex post facto legislation is permissible. And we're going to discuss that in greater detail when we go to the case of Polyukovich versus the Commonwealth. Now, what I'd like to do next is just to make a clarification about certain rights and freedoms. So we've spoken of constitutional rights. Some of them are expressed, such as the right to religion or the right to interstate trade and commerce. Those are express rights. And the right to just compensation, for example, for property that would be acquired by the Commonwealth. So those are express rights guaranteed by the Constitution. And we've also spoken of implied constitutional rights and freedoms, such as the freedom of political communication, or we've also said the freedom against bills of attainder. Again, these are implied freedoms of the Constitution. Now, there are other freedoms that are, or rights that are recognized by the courts, but are not considered part of the Constitution themselves. And some of these, for example, would be the right against arbitrary retention or the right against confiscation of property. So the High Court, for example, recognized in the case of Chukeng Lim versus Minister for Immigration that the arbitrary detention of a person would be impermissible and it would therefore be illegal. It's also recognized by the court that confiscation of property must be based on a valid law passed by the parliament. So these are common rights or rights that emanate from their recognition by the courts. What this means, however, is that because they are common law rights and they are not constitutional rights, these common law rights are thus subject to be displaced or subject to modification by an act of parliament when the parliament expressly provides otherwise. So what this means is a common law right, for example, maybe the right to privacy or the right to detention can be varied or changed according to a determination by a statute passed by the Commonwealth Parliament. So because common law rights are always subject to be displaced or changed by the Commonwealth Parliament. So that's the distinction. Whereas if it is a constitutional right, it is a right that cannot be abrogated or violated by any law of the Commonwealth Parliament or even any law of the states. However, if it is a common law right, it is subject to a variation or displacement by a valid act of the Commonwealth Parliament. There are also certain rights that are based on statute or based on law. These could, for example, include the right to education, the right to health, the right to housing, and so on. In a lot of jurisdictions or in other countries, there is no such thing as a right to education. Meaning if you're poor and you don't have the money to go to school, and because to go to school, you need to pay tuition fees, even for primary education, then you're out of luck. But in Australia, obviously, the right to education is guaranteed up to the level of high school. And in some countries also, the right to education is even guaranteed up to the level of the universities. Now, but the thing is, because it is a statutory right, it is a right that is founded on an act of parliament, meaning it is a grant of the Commonwealth Parliament, it can be changed. And that leads to a crucial question. If there is a guaranteed right to education, for example, if tuition fees are excessively increased so that education becomes difficult to afford, would that violate the right to education, at least the statutory right to education? So that leads to certain interesting questions. But again, it all depends. That right, therefore, is heavily dependent on what the law provides, because that right is based on law, which law is not constitutionally protected. Therefore, it can be changed at any time by the power that grants it, or in this case, the Commonwealth Parliament. Now, let's speak of the important case of Polyukhovich versus the Commonwealth, or the War Crimes Act case. So the interesting thing about the War Crimes Act case is that this was a proceeding against Polyukhovich, who was then already an Australian citizen. But he had been charged under the War Crimes Amendment Act of 1988 for war crimes he allegedly committed in the Ukraine, when it was under German occupation during the Second World War, particularly during the period between 1 September 1941 and 31 May 1943. So at the time that Polyukhovich was alleged to have committed these acts, they were legal then. There was no law that prohibited war crimes. So he committed acts in 1941 and in 1943, long before we were born. So this happened during World War II. Later on, so at the time that Polyukhovich committed this, there was no crime against it, okay? They were legal. It was legal to commit war crimes then, because war crimes had yet not been defined, not even in Australia. And, but later on, Polyukhovich migrated to the United States, and eventually he became an Australian citizen. Once he was already in Australia in 1990 and 1991, a criminal proceeding was then started against him on the basis of acts that he committed in 1941 up to 1943. And obviously, Polyukhovich questioned the legality of the amendment of the War Crimes Act, because it retrospectively sought to criminalize behavior, according to him, that at the time it was committed was actually valid, because there was then no law that that made it a crime to commit certain war activities, such as the slaughter of innocent civilians, for example. And so he questioned the constitutionality of the War Crimes Amendment Act as constituting an ex post facto legislation, which in most democracies is a constitutionally protected right, including in the United States, as I stated. And secondly, he said that it was not within the legislative power of the Commonwealth Parliament to pass a law for acts that were committed outside of Australia. Now, obviously, in relation to the second legal challenge, you would know the answer, right, by this point. So if the question was, you know, if Polyukhovich raised the challenge that he couldn't possibly be made criminally liable for acts he committed in a foreign country such as Austria or such as Ukraine, because, you know, on the basis, for example, of the notions of territoriality in international law, the jurisdiction of any state is limited to its territory or to its subjects. Now, obviously, the War Crimes Amendment Act sought to criminalize behavior that occurred outside Australian territory and involving someone who was not then a subject of Australia, because at the time he was not an Australian citizen. And as we already know, based on our previous tutorials and lecture podcasts, that's easy to decide, and we would easily state that that law cannot be challenged on the basis of an act of Parliament that criminalized behavior occurring outside of Australia, because under the external affairs power of the Commonwealth Parliament in section 51, particularly subsection 29, it was within the power of the Commonwealth Parliament, using its external affairs power, to legislate in relation to matters or subjects outside of Australia. So that second legal challenge was quickly thrown away by the High Court. Now, in relation to the notion of ex post facto legislation, the court was heavily divided on this. And it was actually by a majority of 4-3 that the High Court ruled that the idea that ex post facto legislation is prohibited in Australia is not the case. So the High Court, by a majority of Chief Justice Mason, Dawson, Toohey, and McHugh justices, the High Court rejected the challenge against prohibitions concerning ex post facto legislation. And in this case, the High Court ruled that the external affairs power supports the validity of Section 9, which was what criminalized the act of Polukovich, even if it happened between 1941 and 1943 in the Ukraine. And as reasoned by Chief Justice Mason, he said, if for some reason an ex post facto law did not amount to a bill of attainder, yet a judge presents guilty of a crime or imposed punishment upon them, it could amount to trial by legislature and a usurpation of judicial power. But if the law, though retrospective in operation, leaves it to the courts to determine whether the person charged has engaged in the conduct complained of, and whether that conduct is an infringement of the rule prescribed, there is no interference with the exercise of judicial power. So there are two observations we should be making here. Ex post facto legislation is not deemed by the High Court in Polukovich versus Commonwealth to be a violate any constitutional prohibition, because it still leaves it to the court to determine the guilt or innocence of a person. And so therefore, as far as the exercise of judicial power is concerned, it leaves intact to the court the power the power to exercise its judicial power in relation to a matter or in relation to an actual controversy. On the other hand, if it had been left to the legislature or to an executive to determine the guilt or innocence of a person, that would be something else. That would amount to a bill of attainder. And that would be constitutionally proscribed or prohibited, not because ex post facto law legislation is impermissible or bill of attainder per se is impermissible, but because it would violate the partial separation of powers, which leaves or reposes in Chapter 3 courts the judicial power and the power, therefore, to make determinations involving matters or where there is an actual controversy involving rights, interests, or freedoms or legitimate expectations of persons. Now, what then, having made a discussion on the rights and freedoms, what then exactly is the role of courts? And so we can see that courts are crucial because given the fact that we have a partial separation of powers where there is a kind of a fusion of both the executive and the legislature, because the executive is composed of the cabinet ministers and the prime minister are part of the legislature. So therefore, and obviously if you're the prime minister and you have the cabinet, the cabinet ministers, you belong obviously to the ruling coalition, to the ruling party. And so therefore you have every opportunity to determine what the legislative agenda will be. You can determine what laws will be passed because you have a majority in the parliament. So because of the partial separation of powers, there is no full separation of powers because the executive and, as we said, and the legislature are in a sense in Australia fused. It remains to the courts, therefore, as the final bulwark against any violation of constitutionally protected rights and freedoms, and also to ensure that the demarcation between what powers belong to the federal parliament and what powers belong to the states are clearly demarcated and established. That belongs to the courts. So therefore, the courts become a crucial check, not only on the Commonwealth Parliament, but also a check on the executive. Now, what the courts then do is to ensure that the laws passed by the Commonwealth Parliament are consistent with the Constitution, mainly because, especially in relation to the power of the Commonwealth Parliament to pass legislation, in Section 51, which we said, as we said, is the basis for the Commonwealth Parliament to pass laws. The power of the Commonwealth Parliament in Section 51 is subject to the Constitution. So the power of the Commonwealth Parliament, therefore, to legislate has to be subject to the Constitution, to the other provisions of the Constitution, as well as any implied limitations that arise therefrom, which includes the federal nature of the Commonwealth, the separation of the federal judiciary from the other branches of government, as well as the fact that we are in a free society that is governed in accordance with the principles of representative parliamentary democracy. And I'd like to just quote something that Justice Dawson said in Australian Capital Television Proprietary Limited versus the Commonwealth, where he said, the Australian Constitution, unlike the Constitution of the United States, does little to confer upon individuals by way of positive rights those basic freedoms which exist in a free and democratic society. They exist not because they are provided for, but in the absence of any curtailment of them. So what Justice Dawson is saying is that we have certain rights and freedoms, not because it was granted by the Constitution, but because the Constitution did not say that we cannot exercise certain rights. So what it tells us is that if there is no prohibition against us doing certain things, and we will recall the principle of legality here, then we should have the freedom to do that in the absence of an express or implied curtailment of that right or freedom by law or by the Constitution. Okay, so that it says they exist not because they are provided for, but in the absence of any curtailment of them. So if you go by, if you remember the rule, the principle of legality, there are two aspects of the principle of legality. One is that the executive officers may only do acts on the basis of a law, and that law can be the Constitution, it could be a statute, it could be a government regulation, or it could be a common law principle that is recognized as authorizing the executive officers to do certain acts. The other aspect of the principle of legality, if you remember, is that any person can do anything he wants to do for as long as it is not prohibited by law. And that's exactly the notion, the nature of a democracy. We can do anything we like to do for as long as it is not prohibited by law. Right? I mean, we do not need any law to tell us that we can do this or that. So we don't need a law to tell us that you can pee on your floor, or you can get drunk on the street. You can do that. You don't have to ask permission to do that. However, for you to be prohibited from doing something, it will require a law to do that. Okay, so you can do anything you like for as long as there is no law prohibiting you from doing something. And that is what Justice Dawson was saying in the case of Australian Capital Television Proprietary Limited versus the Commonwealth. And so before we end this lecture podcast, let's just go briefly through some case problems which I had initially raised at the start of this lecture podcast. So as far as arbitrary detention and detention are concerned, as we said, there is no constitutionally recognized rights and freedoms concerning unlawful arrest and detention. However, the High Court has clearly said in the case of Chukan Lim versus Minister for Immigration and Ethnic Affairs that the right against arbitrary detention is a common law recognized right, meaning it has been recognized by the courts, so that no person can be subject to unlawful or baseless arrest and detention. And so therefore, if there is meant to be any detention, it cannot be arbitrary. There has to be a lawful basis for it. So in other words, would there have been a necessity to detain a person for the purpose of ensuring that no crime will be committed if he attempted to commit a crime, or to ensure that he can be brought then before the courts to answer a criminal charge? So the scenario I gave, for example, would be a situation where an Australian citizen, for example, has been in detention for 10 days, in detention with the police, and no criminal charges have been filed against him in court. So therefore, the court has not acquired jurisdiction over that person. And the court has also issued an order allowing him to continually be detained in in the police premises. The question is, assuming there was such a law that authorized such an action, would that be legal? And I would argue that in relation to that Australian citizen, it would be legal because it does not amount to an arbitrary arrest and detention. And if you go with the case of Chukan Lin and Alcatel versus Goodwin, the High Court ruled that the limitation is against arbitrary detention, and in that case, that wouldn't be arbitrary detention. And the other point that the High Court emphasized was that, for example, to detain a person on the basis of a quarantine against diseases would be legally permissible, or the detention of people who might be mentally ill and prone to commit criminal behavior might also be permissible. And in those cases, the detention would not be arbitrary. And the notion of arbitrary detention, therefore, relates to the idea that it is for the courts to impose punishment and to determine guilt. And in these instances, there is no argument to be made that there was an unlawful detention, because there was no punishment. The fact alone of detention is not punishment, and neither was there an adjudication of guilt. Now, but that is in relation to a citizen. But however, if the detention, let's say, has been for 30 days or more, it is likely arguable that that would be illegal detention, because there seems to be no justifiable reason why that person cannot be shown before a court for the purpose of the court making a determination whether or not that person should remain in detention or be permitted to be free from police detention upon providing bail, for example. Now, the example I gave was on the basis of an Australian citizen. In the case of Alcatel versus Goodwin, the High Court ruled that the situation would be different if a person who has been detained is actually an alien. In other words, he is not an Australian citizen, and neither is he an Australian permanent resident. In that case, it would be different, because a detention that might even be deemed indefinite, such as that case of both refugees, it's possible for them to be detained in the refugee camps, or what do you call them, the detention centers, for, let's say, a period of 2 years to 3 years even. In other words, that detention seems to be quite indefinite, because it can range between remaining in the detention center from 1 day to even 3 years. The question is, and we know it's detention because they have nowhere else to go. They're stuck in that place. They can't leave the area or the detention centers. The question is, would that be invalid? And the High Court ruled in the case of Alcatel versus Goodwin that is a valid act of the executive, as allowed under the Migration Act. So in other words, the Commonwealth Parliament's law under the Migration Act giving the executive officers that power to detain persons for an indeterminate time against aliens is permissible, because in that case, it is not considered a punishment to detain them. The purpose of the detention was to determine whether or not they should then be asked to leave Australia forcibly. It's not about leaving forcibly. It cannot be asked, but for the purpose of determining whether they should be forcibly removed from Australia. So the case of ex post facto law and the Bill of Attainder, we've discussed that. So a law that criminalizes behavior that at the time it was committed was legal is likely to be upheld on the basis of the case of Polikovich versus the Commonwealth, but a Bill of Attainder would be impermissible or would be unconstitutional. Concerning spying and surveillance, so let's assume that there is a law which gives the ASIO or the police or certain executive officers the power to spy and intercept every email, every mobile communication, every phone conversations by ordinary individuals on the basis of an attempt to combat terrorism. So in that case, the Commonwealth Parliament might be citing its external affairs, its defense powers, or it may even cite its external affairs power on the basis of the fact that international terrorism, the desire to combat international terrorism, especially in light of jihadis or in light of the ISIL movement or ISIS in Syria and Iraq, mean that Australia has to be part of the movement to combat international terrorism. So it relies both on the defense power and at the same time it relies as well on the external affairs power of the Australian Constitution. So would that kind of spying and surveillance of Australian citizens be valid and legal? And the answer would be unlikely not. Okay, so while the external affairs power under the engineer's doctrine is meant to be expansively construed so that even if the legislation contains subjects or matters which are beyond whatever international commitments that Australia may have agreed to in a treaty or in any international instrument, still there is an assumption that because Australia is a representative parliamentary democracy, it is unlikely to be the case that it would be valid for the police to have such intrusive, extensive, draconian laws that would subject the lives of every single Australian to scrutiny, and for their rights against privacy to be invaded. That would be like a big brother watching. Yeah, big brother watching every single thing that we would do. That would offend the Australian Constitution because there is an implied right that we are a free and representative democracy. The burning of the Australian flag, if somebody burned the Australian flag, that is likely to be a guaranteed right as a part of the freedom of political communication. So after studying this topic, you should be able to discuss and explain the constitutional basis for the rights and freedoms of Australians, despite the absence of a Bill of Rights, discuss and explain the constitutional constraints on governmental powers to interfere with the rights and freedoms of Australians, discuss and explain the implied freedom of political communication and freedom from arbitrary detention, and discuss and explain how and why an ex post facto law can be valid in Australia. So that will be our last lecture podcast for the term. And I thank you for taking the time to go through all the lecture podcasts and for putting in the effort to do well in our course. And all the best in your future endeavors, and all the best in your coming final assessments. And I hope to see you soon again in one of the future courses. And all the best in your attempts to become an Australian solicitor. Goodbye for now.